I wonder if I can take you back for a moment to where we were before the adjournment. Do we have in the bundle the material that was before Mrs. Justice Jeffreys, which persuaded her that alternative remedies were unsatisfactory?
No, we don't have all the evidence that was before the judge, no. Obviously that can be provided.
I think it might be helpful to us to have that.
Yes. I think it probably was in one of the bundles below, possibly even in the Court of Appeal bundle, but I can make inquiries and provide it after the hearing.
Can you tell us in a nutshell why bylaws weren't an alternative?
Yes. To make a bylaw, one has to submit the proposed bylaw to the Secretary of State on 2 occasions, and it takes a very long time. There were 60 different sites, and different bylaws would have been needed for each site. And what's more, some of the sites at least, perhaps most of them, were of the nature that their use would change over time. Some of them were development land, for example, and so the bylaws wouldn't be appropriate for the long term. Nobody has thought that bylaws could work in this situation. And, my lords, the police, quite rightly, approach these cases with a light touch. I'm conscious that I'm giving evidence, but it's the nature of things that...
Yes, no, we've asked you, so it's
yeah.
fair enough.
The police don't enjoy interrupting gypsy and traveller encampments. To criminalise such encampments by bylaws isn't thought to be the right answer. Now, I hear the submission from Mr. Drabble and from Mr. Bunting that these orders effectively criminalise behaviour, but they don't. Trespass is already unlawful. And if somebody comes to the court with an existing right where there is a real and substantial threat that it is about to be infringed, then it is wrong in principle to characterise the resultant court order as criminalising behaviour. These injunctions are no different from any other injunctions in this respect. They enforce rights, and they are, in the main, in the vast majority of cases, they are obeyed, and there is no question of criminalisation.
Well, they do have a power of arrest attached to them.
They can do, and ours did. They don't have to. And I accept that if somebody breaches the injunction, they put themselves at risk of arrest, and that looks very criminal.
I mean, I appreciate it. I mean, we all appreciate it's not criminal. You don't get a criminal record.
No.
You're not convicted. You're not.
I'm not.
So on. But there obviously, functionally, there are a number of similarities.
Yes, but it's not. Well, perhaps I'm wrong. I don't need to submit that it doesn't criminalise. Perhaps the better term is that it's not equivalent to legislating. It's not equivalent to creating criminal offences. It's equivalent to enforcing existing rights and obligations with the usual consequences if somebody disobeys a court order. And remember that there is no right to a power of arrest except in fairly extreme circumstances.
In the order itself, at page 800, What is the provision? I recognise there is a provision there for service of the deemed service of notice of the order on anyone who sees the. I beg your pardon. Paragraph 4 on page 802 talks about alternative methods of service for the injunction.
Yes.
Is that the way in which, in your submission, these persons become parties to the proceedings, or do they become parties to the proceedings when they, in some way, breach the order?
They become party to the proceedings, preferably when they come to court in order to be varied or discharged.
If they don't do that?
If they don't do that, they don't become parties to the proceedings. Unless, of course, they're one of the small minority who breach the order, then they become parties.
They become parties because?
Because they have breached the order. Well, because they are now one of the people undertaking the conduct which is described in the order.
So is it really correct to describe in paragraph 4 that the methods that are there listed as service? Not really, because you're accepting that there isn't service unless they challenge the order or they breach it.
Yes, I appreciate and accept that. Service, in fact, has two functions. One of them is to bring the proceedings to the notice of the defendant. The other is to make sure your claim form doesn't expire.
Yeah. So it's really a notificatory provision as much as anything. Yeah.
This service means that the claim form doesn't expire. It does have that effect.
Yes.
And in fact, if your lordships are looking for problems with how service fits in cases like this, there is a problem to be found in paragraph 5 of the order, in which service of the injunction and power of arrest shall be deemed to have been effective at midnight after the last step has been taken.
Well, I mean, I have a problem with the whole of the order for service, page 771, that it's purportedly made under CPR Part 6, or rather, alternative to CPR Part 6, and yet there aren't any defendants on your analysis because the order hasn't even been made, so nobody could be applying to set it aside, and nobody by definition can possibly have been in breach of it.
Well, there will be defendants if the order doesn't work. And that's the important time. One should be looking at this not from the perspective of the date that the order is made, but from the date of the conduct which it is intended to curtail.
Sorry, I thought the purpose of Mr. Judge Cook's order was to set up a scheme for service so there could be an effective hearing in October, 3 months later. But at the moment, I don't see how it worked by way of service of anything. It worked by way of notification, certainly.
Yes. Well, there would be an effective hearing in October if any of the many people to whose attention this application came and who were affected by it, for example, travellers' associations, if they had turned up at the hearing, there would have been a contested hearing, and it was service of the traditional sort on those people.
Yeah.
Well, but in terms of the order, service is deemed to have taken place as soon as the last of the steps outlined set out by His Honour Judge Cook is carried out.
Yes, and I accept there is a problem with deeming service on a date when some of the people affected by the order won't have seen it yet. But these are problems of a practical nature that can be solved. If these problems created manifest injustice, then I'd be in difficulty. But they don't. The only problems that I'm facing with these questions are problems because the rules don't accommodate properly this sort of injunction yet.
Yes. and they're leading us to consider exactly what kind of injunction this
Yes.
is.
And as I said at the outset, we're comfortable that this injunction will work according to the GAML principles, but we've always been the party in this litigation from the hearing at first instance in front of the judge and in the Court of Appeal, who have said, if it's a contra mundum order, fine. There's nothing. It's not logical to say that because Venables engaged convention rights, that therefore contra mundum orders must also always engage convention rights. If it's the most convenient and just way of exercising the court's powers under Section 37, then it has to be right. Unless Mr. Drabble can persuade the court that there is an inevitable lack of fairness in every application. Every application. I would adopt gratefully Mr. Giffen's point that the appellants have set themselves a very high bar here.
Can I ask you, will we find the matters you told us about bylaws, that the number of applications that have to be made to the Secretary of State, the need to have separate bylaws in respect to every piece of ground that's going to be affected, is that going to be apparent from the statutory provision in the Local Government Act, I think of 1972, on which they're made?
My Lord, can I be clear that the answer that I gave to the court about bylaws was an answer communicated to me by one person from Wolverhampton, a solicitor, who doesn't have personal experience of bylaws, and was instructions I took at lunchtime.
Well, that's very frank. Perhaps when you have time, or those behind you have time, we could be provided with chapter and verse.
Certainly, be grateful. Yes.
Shall we say, we've asked you for, there are a number of documents we've asked for. Could we ask that they be given to us within 14 days from today?
Certainly.
Thank you.
They will take some collating, but that's a
Yeah, so if you need longer time, just communicate with our registry, and
yes.
that can be considered.
Thank you. Bromley. If we could go to Bromley, it's at tab 9, page 2173. I think I'm going to have to skip taking you to the paragraphs that reading out the paragraphs. But the first point is that this was plainly seen by the court as a test case. And that's made clear in paragraph 1, where the Lord Justice Coulson sets out by saying he's going to provide some guidance about these sort of cases. And paragraph 2 clearly records the understanding of that court, that the challenge which these cases provide for the adversarial nature of litigation in the absence of a defendant. So those were the challenges in mind in this test case. And if your Lordship cast an eye at the representation just above Lord Justice Coulson's judgment, you see a cast list of the usual cast list, if I can put it that way, many of whom are here today. If we go to paragraph 32, Lord Justice Coulson underlines the Article 6 problem at the Audi alteram partem problem, if you like, and again underlines that is what he's dealing with. And in paragraph 34, he says this has the consequence that a court should always be cautious when considering granting injunctions against persons unknown, particularly on a final basis, in circumstances where they're not there to put their side of the case. This was a final injunction case, and the judge at first instance had in fact granted a final injunction against persons unknown, newcomers, against fly tipping, but had refused an injunction against encampments, because one of the reasons being it was an application for a borough-wide injunction. Now, at paragraph 39, his lordship considered a number of other cases that had been assembled, that had been tried and fell for consideration, including the Wolverhampton case at letter C, or subparagraph B, and he actually quoted from Mrs. Justice Jefford's judgment. And the structure of the judgment, which I commend to your lordships as well worth paying a lot of attention to, there's a heading at 5.3 with a helpful discussion of Article 8 and the Gypsy and Traveller community, paragraph 40. Then at 5.4, the court deals with relevant statutes and other guidance. At the guidance part of that, beginning at 54. Then we have the analysis of the appeal. One point I would make from paragraph 60 is that plainly the judge at first instance and the Court of Appeal thought that the INEOS safeguards that your lordship alluded to yesterday, including number 3, are cumulative with the safeguards that are being laid down in this case, because the judge at first instance had found that the 6 requirements in INEOS had been satisfied in favour of the claimant, and yet had still refused the judgment, the injunction. Paragraph 70, paragraph 68 begins the heading alternative sites, which is one of the factors. And Wolverhampton gets a favourable mention in paragraph 70. And then the wider guidance begins at 99 under heading 7. I haven't got time to read it out, but it demonstrates that these injunctions are certainly not easily obtained. Before this case, it's true that there were a number of questionable injunctions granted. But after this case, there were not, because it lays down stringent guidelines. Unless, of course, Mr. Justice Nicklin was right that all such injunctions are legally incompetent. Paragraph 105, again, we're commended. The solution in Wolverhampton identified particularly vulnerable sites, but did not include all the sites owned by the council. It was a proportionate answer. And the same is true of the duration of the injunction. So we again, the 3-year duration with reviews gets a tick. So it makes clear that these are exceptional orders that are only granted in narrow circumstances as a last resort. And we submit that that feature of this case falsifies the floodgates argument that is a feature of the appellant's case. We would invite the court not to seek at this hearing to stiffen the Bromley and INEOS guidelines. There is no challenge to the detail of these guidelines has been mounted, and there is no reason to suppose that unless such injunctions are legally incompetent altogether, there's no reason to suppose that there's anything wrong with this guidance. This court has not had the assistance it would need, in my respectful submission, to tinker with the guidelines. We submit that these cases, Ineos, Bromley, and this Wolverhampton's case, show that judges are capable of assessing the individual facts of a case and balancing the various rights in play. And indeed, at the second review hearing of our injunction, which happened after Bromley, perhaps unsurprisingly in view of the dicta in Bromley, Mr. Justice Martin Spencer said that he had no trouble in finding that our injunction complied with the Bromley guidelines and continued it. That was after the transit site had become available.
It's not directly relevant, but I'd be interested to know, in 104D, they speak about the general obligations to provide accommodation in transit sites, but are we being told it's not a statutory obligation? Is it simply government guidance?
Yes, that's right. Yes.
So it's not a legal obligation as such?
Well, I think that a local authority is probably under a legal obligation to comply with government guidance unless there's a good reason not to. But certainly, speaking for Wolverhampton, Wolverhampton has always taken seriously its obligation to provide sufficient accommodation and transit sites for the Gypsy and Traveller community.
Well, I don't wish to increase your burden, but I think it'd be useful to just know chapter and verse as to how local authorities are under this obligation, as the judge says here.
Yes. We'll add that to the list. Can I make 3 points next about Venables? Firstly, we submit that the Venables injunction was not an exception to the fundamental principle. That being the fundamental principle that the court doesn't make orders without giving the subject of the order an opportunity to be heard. Because there is no requirement of the fundamental principle that it has to be satisfied at the day upon which the court first pronounces an opinion, first pronounces judgment, if that judgment permits somebody to come back later to challenge the order who wasn't before the court when it was made. And of course there is CPR 40.9, which embodies that principle, which provides that a person who's not a party but is directly affected by a judgment or order may apply to have the judgment or order set aside or varied. There is always, and was at the time of Venables, that provision. So there was no, Venables is not an exception to the fundamental principle, and neither is Wolverhampton's injunction in this case. Secondly, Venables wasn't really about contra mundum injunctions. It's only because of the Master of the Rolls' mention of it in the context of such injunctions in Canada Goose that those engaged in these cases have come to think of it as a case about contra mundum orders. It's not. It's a case about the freedom of the press and whether serious criminals should be entitled to suppress their identities and information about their whereabouts from publication. Those were the concerns before her ladyship in Venables, and those were the matters about which she about which she wrote in her judgment. She identified in paragraph 10 of the judgment the major issues that were facing her. Not one of them was, is it okay to grant a contra mundum order? What about spycatcher? She only turned to that issue at a very late stage in the judgment, at paragraph 98, and disposed of it in 3 short paragraphs. The case is certainly not authority about injunctions contra mundum. And the third point I wanted to make about it, I've already made actually, that because there were convention rights in that case, doesn't mean that there must be convention rights before such an injunction can be fashioned. And of course, convention rights are wide and various. We see that in OPQ and BJM, the case mentioned in paragraph 67 of our written argument, an injunction was granted contra mundum to protect an individual against publication of embarrassing photographs. It's impossible, of course, impossible to compare whether the harm to that person of having those photographs published is worse than the harm to the people of Wolverhampton as a result of some of the activities which Mrs. Justice Jeff had heard about. It would be a reductive comparison. But that actually only demonstrates how unprincipled it is to seek to confine these sorts of injunction to a particular class of case. Because the moment you do that, you invite exactly those sort of comparisons. Finally, can I mention, as Mr. Giffen did, the matters mentioned in paragraph 92 of our written case, 92 onwards. The car cruising injunction in Birmingham was allowed to lapse after Mr. Justice Nicklin's decision. And it was not until the decision of the Court of Appeal in this case that such an injunction was obtained. And that's the report that Mr. Giffen's already drawn your attention to, the case of Dangmadin. It's important to note that car cruising involves a threat to life, but it also involves massive disruption of localities. And it was a direct result of Mr. Justice Nicklin's decision that such an injunction had to be abandoned. Now, the final point I'd make is that Mrs. Justice Hill, who granted that injunction recently, didn't grant it in order to allow the claimant to identify some defendants. That is the only purpose of an interim injunction that Mr. Justice Nicklin would allow in these cases against persons unknown. See paragraphs 130.1 and 136 of his judgment, which he based on paragraph 92 of Court Canada Goose. The purpose of the injunction was to stop the activity, and it succeeded. And during the period when Mr. Justice Nicklin's judgment stood, nobody could think of another way in which the courts could restrain car cruising. My time is up, but is there anything I can assist with?
I don't think so. Thank you very much indeed, Mr. Anderson.
While Miss Bolton organised, I just mentioned, as I should have done, it is in our case and the statement of facts and issues that Walsall does not seek the reinstatement of its injunction. It's an old pre-Bromley one, and that's why you've heard nothing from me about the particular facts. I apologise for not making that clear first time round.
Yes, Ms. Bolton.
My Lords, good afternoon. My Lords, my submissions are going to concentrate on why, in particular, travellers' injunctions are an exception to the spy-catcher principle when the injunctive relief includes a claim pursuant to Section 187B of the Town and Country Planning Act. if the court is not with the respondents generally on issue 1, it's my submission that it must be the case that specifically in relation to section 187B, the courts can grant an injunction that binds newcomers. We deal with the point in our written case at page 330. I won't take you to that now, but that's where you'll find the written arguments in relation to this point. My Lord, each of the 3rd to the 10th respondents that myself and Ms Pratt represent sought alternative service orders prior to seeking in any interim relief. They gave notice of the hearing, the claim form, and the order sought and the supporting evidence prior to that hearing. And generally, having a quick look at the question having been asked of Mr Anderson earlier, generally that was about a month before any hearing took place. Each of these local authorities provided significant evidence before the court around, and I'll take your lordships to one of the judgments later, of around 7 lever arch files of evidence of the harm and the impact suffered generally that led to the injunctions being sought in the first place. And, my lords, each of those injunctions relied upon breaches of planning control. Those breaches of planning control being both the change of use of land, and that was in relation to changing the use of the land to a temporary stopping site, and the land used ranged from, and again you'll see this when I take you to the Redbridge judgment, that ranged from schools to private businesses to local authority land, among others. And it also concerned change of use of land to a waste site, because some of this land was significantly fly-tipped. And again, you'll see reference to that and the costs involved in the judgment of Mrs. Justice Farby in the Redbridge case, which I'll take you to shortly. First, I'd like you to take you to the decision of South Buckinghamshire District Council and Porter, which you'll find at page 4349 in the bundle. 4349, my lord. Now, this was a case which concerned the approach to be taken to section 187B in travellers' cases concerned with the unauthorised development and change of use of land, so different to the encampment cases, following the introduction of the Human Rights Act and the approach that the court needed to undertake. But in part, as part of this decision, the House of Lords considered the entitlement to grant an injunction under section 187B. And if I can ask you to look at paragraphs 28 to 29 in the judgment, which is at
4369.
I'm grateful, my lord, it's 4369. You'll see in those two paragraphs that what is being discussed is the court's power to grant an injunction, and it says that it's permissive may in subsection 2 applies not only to the terms of any injunction the court may grant, but also to the decision whether it should grant an injunction. It is indeed inherent in the concept of an injunction in English law that it is a remedy that the court may but need not grant, depending on its judgment of all the circumstances. underpinning the court's jurisdiction to grant an injunction in section 37(1) of the Supreme Court Act 1981, conferring power to do so in all cases in which it appears to the court to be just and convenient to do so. So, my lords, it's apparent that the House of Lords, when considering the entitlement to grant an injunction under section 187B of the Town and Country Planning Act, confirmed that section 37 of the Senior Courts Act, as it now is 1981, underpinned the court's jurisdiction to grant the injunctive relief. And also we say section 187B is a statutory exception to the usual principles under spycatcher because the statute permits a claim to be brought against persons unknown, and the jurisdiction to grant an injunction under section 37 of the Senior Courts Act underpins the court's jurisdiction to grant that relief. And we see that same consideration in the judgment of Lord Sumption in Cameron. And if I could ask you please to turn to page 2202 in the bundle. And then to page 2208 for the relevant part of the judgment, you'll see paragraph 8, and it's a paragraph that Mr. Drabble took you to yesterday with the heading Suing Unnamed Persons. And in paragraph 9, we see Lord Sumption start to consider the exceptions to the general rule against suing unnamed persons. And you will see that paragraph 9b on page 2209, the relevant part of that paragraph, where he says, in addition, there are specific statutory exceptions to broadly the same effect, such as the exception for proceedings for an injunction to restrain any actual or apprehended breach of planning control under section 187B of the Town and Country Planning Act 1990. Section 187B3, as inserted by section 3 of the Planning and Compensation Act 1991, provides that rules of the court may provide for such an injunction to be issued against a person whose identity is unknown. The rules are supplemented by a practice direction which deal with the administrative steps involved. And so we see that Lord Sumption in that paragraph is considering section 187B3 as a specific statutory exception to the general rule that proceedings may not be brought against unnamed parties. If we can turn to section 187B, please, you'll find that at page 1980.
I'm so sorry, could you give me that page number again?
It's 1980, my lord.
Thank you.
I invite your lordships just to read the section in full. So when considering section 187B as a whole, the section provides the following. Under subsection 1, a local authority can seek an injunction to restrain any actual or apprehended breach of planning control. Accordingly, the local authority only has to apprehend a breach of planning control for an injunction to be applied for. 2, on an application under this section, the court may grant such injunction as the court thinks appropriate for the purpose of restraining the breach. Again, we know that gives the same wide discretion as under section 37 of the Senior Courts Act 1981. And 3, rules of the court may provide for such an injunction to be issued against persons whose identity is unknown, and that's subsection 3. And this subsection concerns the issuing of proceedings against persons unknown, and by its wording, it is implicit that the statute is recognising that an order can be made under section 187B against persons unknown.
Well, yeah, I'm not sure about that. It may be that Parliament is conferring a power for to make rules of court, making such provision. That's not to say that a statutory authorisation was necessarily essential, but it couldn't be done without one. But I mean, this wouldn't have been included if it was simply recognising the status. If Parliament considered it was simply recognising the status quo.
Well, my Lord, I'm conscious that there's a document that was before the Court of Appeal that is not before this court and may need also to be provided to you, and that is the Carnworth report. And in Porter it discusses the fact that this is where these amendments to the Town and Country Planning Act come from. And also perhaps even a paper written by Lord Carnworth that explains the speed of those amendments. And indeed, my Lord, it was a recommendation of the Carnworth report that the injunction should be available against persons unknown, and that how that was to be, the mechanics of that could be worked out by rules of the court.
Yes.
So it may be that document will be of assistance to you as well if there are a number of documents to be provided. My Lords, the rules of the court have been provided until the 1st of October 2022. Those rules were located in Practice Direction 8A, and so that you can see that there is no material difference, that is provided at page 5300. But as of the 1st of October 2022, the rules are now found in Practice Direction 49E, and you'll find that at page 5313 in the bundle. And if we could go to those rules.
Do practice directions fall within the meaning of the term rules of court?
My Lord, I'm sorry.
Do practice directions fall within the meaning of the statutory language, rules of court?
My Lord, I believe yes, they do, and it used to be under the old orders under the Supreme Court and the County Court rules. But it's now under Practice Direction 49E, and I think that's what Lord Sumption is referring to in Cameron as the applicable rules.
Yes. Are you able to assist us on why you say that practice directions are rules of court?
My Lord, well, it's my understanding that they are the rules of the court, but no, I can't assist you any further on that at present. But
they play a far larger regulatory role in the CPR than ever they did under the old RSC regime. There they used to be made by the relevant head of division coming into court one morning at 10:30 and pronouncing it. But now they go through more or less the same procedure as a rule, except it's a different authorisation procedure, because I think the rule goes through negative resolution procedure in Parliament, and the practice direction has a slightly easier route.
Yes, I mean, in this court, for example, practice directions are very different from the rules of court. For that very reason, I can make a practice direction later this afternoon if I feel like it. That our rules are statutory instruments.
my Lord, yesterday the reference was made to how persons unknown are dealt with under the practice direction, and that they don't permit an anonymous person. It doesn't bind persons unknown who are anonymous. That is what I am about to take you to, is that particular practice direction, which is relevant because it guides how you issue a claim under the Town and Country Planning Act, and on what you must provide as part of that claim.
Yes, it seems to be directed towards Lord Sumption's Category 1.
Yes.
My Lord, well, if I may take you to that, because I'd like to look at it both as to what it says and how that has worked in practice, because it works in an important way in practice, which has quite significant implications, not just for these type of travellers' injunctions, but the more routine type of injunctions concerning unauthorised development of land, where development may take place in the green belt and where there is no knowledge as to who owns the land or who is involved in the development of the land. So if I may take you through how this works and how the courts have interpreted that in practice, you'll see paragraph 21(2) expressly provides that an injunction may be granted under section 187B against a person whose identity is unknown to the claimant. The rules also provide for persons to be defined by 1, a photograph, 2, a thing belonging to or in possession of the defendant, or 3, any other evidence. And you'll see in 21(5 that it explains that the description of the defendant, and there's a typographical error there because I think it's a direct copy and paste from the older version of the rules under 8.2. It says that the description of the defendant under paragraph 20.4, so I think that's meant to say 21.4, must be sufficiently clear to enable the defendant to be served with the proceedings. And then it says the court has the power under Part 6 to dispense with the service or make an order permitting service by an alternative method or at an alternative place. And
one of those Delphic signposts, which may be just a signpost, or may tell you something about the meaning of the rule that just goes before it. But on the face of it, 20.5 is quite strict.
My Lord, indeed, it must be clear as to who is being served with the proceedings, and certainly the approach when defining persons unknown under this practice direction is to define them with reference to the evidence, and I'll look at how that was dealt with in the South Cambridgeshire case in a moment. And it's where we see the need for the class of person unknown to be defined with some specificity so that you can actually identify who it is that is being served with these proceedings. And we see that, my Lords, in the South Cambridgeshire District Council case and District Council and Persons Unknown case. If I can take you to that, please. It's at page 2428 in the bundle. And you'll see that the approach to the definition of persons unknown and the ability to bring a claim under section 187B against persons unknown was being considered in this case by the Court of Appeal on a permission hearing. On an appeal. And if you look at paragraph 1, Lord Justice Brooks explains that this is an appeal by the claimants, the South Cambridgeshire District Council, the council against an order made by Judge O'Brien in the Cambridgeshire County Court on the 16th of July 2004. He dismissed an application for an injunction against the defendants, restraining them from causing or permitting the deposit of hardcore or other material on land known as plots 1 to 11 Victoria View, Smithy Fen, Cottenham, which is in the council's administrative area, or causing or permitting the entry onto the land of any caravans, mobile homes, or other forms of mobile accommodation, all using or permitting the use of the land or any of the caravans or mobile homes thereon on the date of the council's application on the 14th of July 2004 for residential or any other non-agricultural purpose pursuant to section 187B of the Town and Country Planning Act 1990. You'll then see, if you look at paragraph 2, how the defendants were described in the original claim form. as persons unknown being a persons other than those listed in the schedule for the claim form, proposing to deposit hardcore and or to station caravans and or to occupy existing caravans on land at Victoria View, Smithy Fen, Cottenham, Cambridge. Now, they were also seeking an alternative service order, and you'll see in paragraph 3 through to 7 that the court is considering the statute and the practice direction, which at the time was under the County Court Rules Order 49 and was in similar terms to the current practice direction. And the Court of Appeal, in that case, were clear how persons unknown were to be defined with reference to the practice direction, and we see that the definition that they thought it ought to be in place in paragraph 3. And then we see them discussing how the definition should operate in paragraph 7, where they discuss the very same requirements as to how you identify persons unknown. And it's plain on this case that the Court of Appeal are defining or ensuring that the persons unknown are defined by reference to the evidence of what is happening on the land. And that has informed the approach that's been taken to defining persons unknown in unauthorised development cases since this case, which is to define it by the evidence. And when we talk about defining by the evidence, we are talking about the activity that is happening on the land. And we say in the same way, in an unauthorised encampment case, you would achieve the same, which would, like in those cases, bind a newcomer by defining them by what is happening on the land.
So even if the statutory words might be read more narrowly, as Lord Briggs has suggested, what the Court of Appeal is doing here is saying, well, in the past there were some difficulties about this, but cases such as Bloomsbury have cleared it up. Is that really the reasoning?
Well, the reasoning is the approach under the practice direction. In this case, it's a Part 8 claim that is issued and brought in accordance with this practice direction, which requires this claim to be brought under the Part 8 procedure and requires persons unknown to be identified with reference to what is now under practice direction 49E. And the Court of Appeal were comfortable that this was meeting that requirement. And when you look at the requirements under the rules, that can only be with reference to the evidence, because they're not being defined with reference to a photograph, and they're not being defined by reference to a thing belonging to or in possession of them. So that has been the approach that has been taken to the defining of persons unknown on a Part 8 claim when dealing with Section 187B.
What does the evidence, what is the evidence that describes the respondent in a Category 2 case?
My Lord, in this case, it was with the reference to what was happening on the land, the laying of hardcore, the changing of the use, the occupation of caravans.
That's a description of the activities by persons unknown. It's not a description of those persons, is it?
No, my Lord, it's a reference to the evidence, which is one of the ways in which you are entitled to describe them. And
Well, just where do we see in this judgment that reasoning?
well, my lord, you see it from the perspective that they have in paragraph 3, they've asked council to change the definition, and in paragraph 7 you see that they are contemplating what is required under the Town and Country Planning Act and what is required under the practice direction. And we then see in paragraph 8, after that discussion, I am wholly satisfied that the statute gives the court the power to make an order of the type sought by the claimants. There was some difficulty in times gone by against obtaining relief against persons unknown, but over the years that problem has been remedied either by statute or by rule. So it's my submission that the courts, having contemplated how persons unknown are to be defined, have been satisfied with that, and that can only be a definition in line with of describing persons unknown, in line with the evidence, because it certainly doesn't fit the category of a photograph or a thing belonging to or in possession of the respondent. But it is obviously in line with the evidence of what was being complained about by the claimant as to what was happening on the land.
Yes, but it seems to be suggested that things have moved on. Whatever the initial interpretation would have been of the statute, things have moved on because of cases such as Bloomsbury. But I won't detain you on this. It's just I was wondering whether this case vouched the proposition that someone was being described by evidence if one used the words listed in paragraph 3 of the set out in paragraph 3 of this judgment.
You've only got a minute or two left.
My lord, I'm very aware I need to move forward. Then,
Well, please do.
It's also important to note that what has been challenged over the last 2 days by both the appellant and Friends of the Earth is not just whether you can bind newcomers under Section 187B, but they also suggest any relief under the section can only be granted on an interim basis. We say that must be wrong for the following reasons. There's no indication in the statute that Section 187B is confined to the interim stage of proceedings. Secondly, an injunction under Section 187B, you must bring the proceedings by Part 8 claim form when seeking an injunction, and the relief that you have to seek is in the claim form, and if you want an interim injunction, you have to bring that as a separate application under a separate application notice. The practice direction makes it clear at paragraph 2110, and you'll find that at page 5314, that the court is concerned with disposing of the claim, and further it's plain that the Court of Appeal in Gamel was not confining itself to binding newcomers at the interim stage, as if you turn to the judgment at page 2412, you'll see at page 2423, paragraph 29, that the Master of the Rolls in Gamel is referring to the important decision in Mid-Bedfordshire and Brown. And that is, of course, a final injunction case under Section 187B that bound newcomers. And you can find Mid-Bedfordshire and Brown in the electronic bundle at page 2403. So Gamel isn't a freestanding decision as to how you deal with the person that comes onto the land after the injunction has been granted. It's building on the decision in Mid-Bedfordshire and Brown and adopting what the Court of Appeal in that case said, and that was a final injunction case.
We haven't looked at it, but I presume from the fact that we have somebody called Brown as a defendant, that it wasn't a case concerned with concerned at least only with unidentifiable defendants.
No, it certainly wasn't only unidentifiable defendants, my lord, but it was named and unidentified defendants, which of course is the case for each of the respondents I represent in these proceedings as well. And my lord, if I may briefly reference you to Mayor, again, I won't take you to it due to time, but at page 4063 in the bundle, and the judgment of Lord Rogers at paragraphs 1 to 4 in the judgment, and his comments there concerning both an interim and final injunction that would bind persons unknown. I'd also invite you to read the judgment of Mrs. Justice Farby in the London Borough of Redbridge's case, which you'll find at page 1358 in the bundle. Again, I won't take you to it due to the lack of time, but the relevant paragraphs to read are paragraphs 10 to 23, where she discusses both the harms that were being experienced in Redbridge, the detailed inequalities and impact assessment that had been undertaken for those who were named defendants, and the considerations that have been undertaken, and the checks and the safeguards that have been put in place.
Could you give me the page number again, please?
That's page 1358.
Thank you.
And my lords, that's typical of all of these, the 3rd to the 10th respondents' case and approach that they took before the courts. I'd also ask your lordships to consider that it's... sorry, I'm just trying to be as quick as I possibly can with a few references.
Yeah, we will have to stop you soon because we need to hear from the remaining interveners.
My lord, indeed. My lord, I apologise. I simply also refer you then to the cases of Vastinton and Leeds, which is at page 4459 in the bundle, and the Phillips case at 3306 in the bundle. Both of those look at the approach to precautionary relief that's been taken by the Chancery Division, especially recently in the Phillips case, which of course, Vastinton and Leeds was approved by the Court of Appeal in these proceedings, and how they approach the issue of harm and the issue of binding newcomers. My lords, unless I can be of any further assistance.
I think not, but thank you very much for the assistance you've rendered us. Yes, Mr. Kimblin.
My lords, linear infrastructure and fuel supplies have been topic areas which have very much occupied these interveners during the course of the last 4 or 5 years or so, in respect of events which are common knowledge as to the way in which infrastructure has been interfered with, particularly linear infrastructure, and supplies sought to be stopped. Those matters are, of course, of great concern to those interveners, but they're also of enormous concern to the public generally. They're also of enormous importance to the economy. The background to the injunctions which have been sought in that regard is that they are focused entirely upon unlawful conduct. That is what HS2's injunctions are about. That is what the M25 injunctions are about, for example. I draw attention to that immediately because the way in which matters have been developed by both Friends of the Earth and by Liberty, has placed a strong emphasis on lawful protest. And I just want to say something about that. Firstly, I want to make it absolutely clear that it's no part of these interveners' case that lawful protest should be in any way constrained. That's not what the injunctions are about. Secondly, that in very many of those instances, what lies behind those matters of objection, the root concerns, are often, for example, climate concerns. There may well be a common ambition in that regard, but one has, in fact, protest activity which is focused upon some particular policy decision which has been made, which has resulted in actions which are much more than mere protest. They are seriously damaging and disruptive. And I just wanted to pick up from there the difficulty which has been obvious throughout this hearing of language and precision of language, because we've had this in respect of interim and final injunctions, but we've also had it in respect of protest, because that which is the focus of the injunctions that I'm concerned with is something which needs much better range of descriptions than the mere word protest. One sort of wants to alight upon the cliche of snow and the Inuit Eskimo words one has for snow. You know, don't we need lots and lots of words to describe what's really going on?
I think they have about 40.
Well, there we are. And to put a bit of colour on that, what we're talking about is pieces of metal being put into trees so that when people come to work on those trees, they're at risk, and that's hampered, tunnelling, and locking on to vehicles, putting people at risk, and causing the express objective, causing delay, cost, etc. So, short point, I'm concerned with the seriously disruptive and the unlawful, not the lawful. In that regard, I propose to touch on 4 topic areas. Firstly, to say something about chilling effect, because the reason that other interveners have drawn attention to lawful protests is because it is said there is a chilling effect. I just want to say something very briefly about that. Secondly, I want to turn to the process which I would submit this court is engaged in, which is some incremental development, starting at first principles, looking at the incremental development of the Section 37 jurisdiction to seek to meet the needs of society today. Thirdly, which is probably the longest section of what I have to say, I want to deal with the question, asking it rhetorically, are the proceedings and the remedies here contrary to principle? And to touch upon the question of interim and final, looking at service and to a degree at knowledge. And then lastly and fourthly, just to touch upon some broader protections which I submit are available. I hope to be able to pick up on some of the points which were in my Lord Reed's shopping list of this morning. I hope under the second heading to say something about duration and costs. I hope under the third heading to say something about service and knowledge, to try and assist on those topics. As to this first topic area, the point about chilling, there are 2 sides to that I would respectfully submit. And 2 points which I need to make first of all. The first is that to really emphasise that none of the injunctions that I'm concerned with have anything remotely to do with lawful protest, and expressly state within their recitals that they do not, and have carve-outs within the provisions which seek to achieve that objective. It may be that some disagree about the measure of success there, but that's what they seek to do.
And can I just ask, do we have them in the bundle, or I see you've got footnotes to your case which gives us citations of authorities. Where's the best place for us to find some examples of the injunctions, if we want to look at them?
Absolutely. Well, my Lord, I will take my Lord to them, and I shall provide the references for sure. In dealing with the question of whether or not there is any chilling effect, the second point to bear in mind is that there is no freedom of forum in respect of protest. And so where one is concerned with restricting the land upon which protest can be undertaken, there is no freedom to go and protest on other people's land. That is important to bear in mind when looking at this question of chilling. Lastly, in respect of this, could I turn, please, to the judgment of this court in Meyer, which is at tab 93. It starts at 4063. During the course of these submissions, I'll go to the judgments of three different judges, but in this instance, it's the judgment of who's then the Master of the Rolls, Lord Neuberger, and that's at page 4086. 4086. 4086. My lords will find paragraph 83. Paragraph 83, in the second sentence, there is discussion there of the question of injunctions and their effect and whether or not it is worthwhile to grant an injunction. I'm particularly interested in the second sentence, but the paragraph is introduced by looking at the question of whether or not there's a real prospect of enforcement. What is said there is that even where there's little prospect of enforcing, by way of imprisonment, etc., it may be appropriate to grant because of the deterrent effect. And so the submission under this heading is that the fact of an injunction will have an important deterrent effect. And while I understand why the submissions were made about chilling effect, there is the additional consideration about the beneficial effect, where there is a real problem to be addressed, of deterrent effect, and that is what is reflected in paragraph 83. Turn then to the second area I wanted to address, which is as to incremental development, and this is a point that I can again develop from this case. In Meyer, what we have in Lady Hale's judgment a little earlier at 4075, are paragraphs 39 and 40. And in these paragraphs, Lady Hale is considering the interaction between possession order and injunction. At first instance, there was in this case, there was a strong statement by Mr. Justice Wilson, I think, who said, well, an injunction is useless here. And this is the sort of topic area that was being canvassed by the Supreme Court in this case. And paragraph 39 starts off by introducing the idea that essentially where there is a right, there ought to be a remedy, and looking at the way in which that might be developed. So the second sentence in 39, the third line in paragraph 39, hesitating to apply it in quite separate land, which has not been intruded upon. The more natural remedy would be an injunction. So they're contrasting possession proceedings and injunction, more natural remedy, and wouldn't hesitate unduly to do so. And this is what I particularly draw attention to in 39. We should assume that people will obey the law, and in particular the targeted orders of the court, rather than that they will not. We should not be too ready to speculate about the enforcement measures which might or might not be appropriate if it is broken. So we then come to incremental development, which in my submission is what this court is largely engaged in. In paragraph 40, there is some caution here from Lady Hale. I would not see these procedural obstacles as necessarily including incremental development, sanctioned in the case you'd referred to called Drury, provided that an order can be specifically tailored against known individuals who have already intruded upon the claimant's land, are threatening to do so again, and have been given a proper opportunity to contest the order. I see no reason in principle why it should not be so developed. So here, I would insert just 2 letters into that phrase. Really, we're considering incremental development tailored against persons unknown, tailored against unknown individuals.
Well, it's a little bit further than that, isn't it? It's unknown individuals who have not already intruded, are not threatening to do so, and have not been given a proper opportunity to contest the order.
Lady Hale might think you were twisting it.
Yes, you may, and do not rely upon it as
Well, you at least rely upon the 2 words incremental development, if not the qualifications.
So that is really the task, and it is really captured there as to what one needs to look at, whether there is a proper opportunity to contest. And that's what I want to come on to next, by reference to the orders which we have in the bundle and which my Lord Reid has just averted to. So, thirdly, looking at this question as to whether or not the proceedings for the remedy are contrary to principle, it struck me that the helpful way to approach that was to look at what's happened, and from that will flow a number of points which the court has been canvassing during the past day and a half. The first place to go, if I may, is at what's at tab 57 in the authorities bundle. So I want to start with what's known as the route-wide injunction. So the route-wide injunction in respect of HS2 result in a judgment which is at 3176. 3176, tab 57. And I will, once we've had a quick orientation by this judgment, go to the order itself. As to opportunity to be heard, and as to what is actually happening in this application, one gains quite a lot from paragraphs 8 and 9 of 3177. So the application notice was for an interim injunction, and what was sought was a final injunction. That came about after there had been a return date in April when Mr. Justice Cotter adjourned the matter in respect to the route-wide injunction for there to be firstly a case management hearing and for there then to be alternative service of the proceedings, and for then to be that the matter was set up as a trial with a view to producing a final injunction. So that's what happened. As we see from the heading to the judgment, it was in September that judgment was given, and that the order was in fact made. And so those who participated had the opportunity to take part in those proceedings between April and the end of that term, and then the judge carefully considered matters before handing down his reserved judgment. What one ultimately sees here is that even though the matter was set up to produce a final injunction, in the end the judge decided to provide an interim injunction lasting for a year. At the hearing, as one can easily see from the lengthy judgment provided, there were extensive submissions by those who were interested, both named defendants and people who came to court and said, "I am a person unknown." The feature of this process is that there is really very, very little to discern as between a process which would be providing interim relief and a process which provides a final order. In fact, it's so stark that everybody attended expecting a final order, and what was produced was an interim one.
Can I just ask, I see you were counsel in the case, looking at what's explained in paragraph 9, was this a without notice ex parte application?
Initially, and then there was a return date at which quite a lot of people attended.
Yes.
At that return date, there was an injunction made in respect of a particular parcel of land, but the part of the case which dealt with the route-wide injunction was adjourned firstly for case management and then subsequently for effectively trial.
Yes. Yes.
This is a Part 7 claim, presumably, was it?
No, this is a
Part
8 claim.
Okay.
So it's an interesting one because you've got a mixture of known and unknown
Yes.
persons.
That's
As far as
precisely
known,
right.
the fact that you've got known ones means that you can't have as the judge explains, you couldn't have a final injunction until you had adversarial procedure.
Precisely.
Yeah.
Before I leave the document, before I leave the judgment and go to the order, very quickly, if we could go please to 3204, 3204. Simply to flag at this point, which is a different point, there the judge begins to consider over some 4 pages the Article 10 and 11 rights of those who might be affected. So from 116 through to paragraph 142, those rights were considered. I draw attention to that to show that in a case such as this, it's perfectly possible to provide that sort of analysis, detailed analysis, albeit that it produces an interim result. As I promised, I will go to the order itself. That's at tab 22. At tab 22, at page 1888, 1888. There is the order. Short point is this, to draw attention to the way in which the defendants are described. I deal with the first defendant, because it starts off with persons unknown, but then describes the defendant as, by reference to entering or remaining without the consent of the claimants, and providing the location. Second, persons unknown, entering or remaining, and then going on to explain with the effect of damaging, delaying, hindering, etc. And so I draw attention to that in the context of tailoring. The order is tailored to the unlawful conduct which is problematic. And that is a feature of such injunctions which is important. And at this point, I'd just like to make a submission about what it achieves in terms of overall fairness, justice and the rule of law, because my lords will recall from yesterday that on behalf of Friends of the Earth, that was the first point that was dealt with. The first submission was concerned with basic fairness, justice and the rule of law. What one has here is an injunction which does grapple with expressly unlawful conduct, but it's in respect of a set of facts where the development concerned is the result of two acts of Parliament where the lawfulness of that consenting procedure has been challenged at all levels, including in this court, and where the executive has decided to go ahead with it. And the stated objective of those who oppose such a scheme is deliberately and consciously to increase costs in order to stop it. If there is a question as to rule of law, then it definitely goes in that direction, that the injunction supports the rule of law and the actions of those it seeks to restrain do exactly the opposite.
It's interesting when you see the recitals on page 1889 that they include a cross-undertaking by the claimants to compensate defendants for any loss that they might incur, and confirmation that it's not intended to prohibit lawful protest, yes, thank you.
Two further, much shorter examples in the same vein. At tab 70 at 3356, the court will find the judgment of Mr. Justice Lavender, who was there dealing with one of the national highways matters. There's a number of them, but I just highlight this by way of example to give the court a flavour of what actually happens. It's at 3352 where it starts, and I draw attention in particular to page 3356, where the judge has a heading, the hearing. Because I discern that the court is interested to know the extent to which people have an opportunity to come along to contest such orders. At paragraphs 18 and 19, what the judge records is that on the return date, people came along and said, can we have more time, paragraph 18, and so the matter was adjourned for counsel to be instructed and for others to come along to address the court, and that recorded at paragraph 19. That's what happened. 9 people came along and made their representations. Precisely the same thing happens in respect of a further example the court has at tab 96. I won't go there. It's at page 4219, where Mrs. Justice Andrews, as she then was, took very much the same approach. In that case, at that interim stage, putting it this way, letting 2 individuals who came along out and giving them their costs and reducing the length of time sought. What one gathers from these examples is that it's perfectly possible to provide an opportunity to be heard, which is not materially different to the opportunity which might be afforded at a trial. What is the difference? It's very hard to tell. So the remaining points which I wish to draw to the court's attention are merely these. So far as, I've got 2 points. So far as knowledge is concerned, I draw attention to what's said about Couturian and so far as that is dealt with at tab 472882. And these interveners' position is that that which is set out at paragraph 13 there, Farnsworth, is what is the long-established position as to what's necessary for knowledge in the context of contempt. And fourthly and lastly, very shortly this, I invite the court to bear in mind the range of protections which there are in this entire process, not least the duty upon advocates to behave in a way which has full regard to what their opponents may say if present, with candour, and also the duty to go back to court in the event that anything arises which the court should know about in respect of any order obtained. So all of those protections are part of the overall context, which I'd respectfully submit necessarily go into the mix when assessing the appropriateness of such an order. Lords, I don't wish to trespass upon Mr. Drabble's reply, and so I should draw to a close.
Yes. I see the order that Mr. Justice Knowles granted was indefinite in duration, but to be reviewed annually. Was it covering an extensive area?
My Lord, that injunction was not covering such an extensive area related to a particular area of countryside.
Yeah, I see. The one where presumably it was anticipated the works, I don't know, was anticipated the works would be taking a period of years.
Yes, because there are advance works which have to be undertaken at certain times of year to avoid harm. And so it's not all done in one go.
No, I see. Thank you very much.
May I just ask one question? The review procedure that you've had in mind in these authorities and provided for in the orders, in a nutshell, what does that involve?
It involves going back to court with evidence as to what has happened, any amendments to the order being made. In particular, sometimes it becomes clear that a named defendant is no longer active, and so there's an obligation to remove them. And it may involve saying that the order is no longer required. It's a full review.
You invite the judge to reconsider whether to continue the order, whether to make the order again effectively for the further period, drawing the attention of the judge to any circumstances which might affect that decision.
That's the burden which is on the applicant, yes.
Thank you.
Yes. I'm not sure if it was in this order or in another that I saw an example of that the order was being discontinued in respect of certain areas of land. Maybe yes, it isn't this one.
My Lord, that was right. To an extent, that is tidying up, because the route-wide injunction captures other land which was subject to separate injunctions, which would then be no longer needed because they were captured in the new injunction.
Yeah. Oh yes, I see. It's on page 1894, paragraphs 12 and 13.
My Lord, that's absolutely right, and that is because Crackley and Covington, for example, were then captured by the route-wide injunction, and the Cash's Pit order, which was made, which 13C, had been also taken in this order.
Yeah.
That was a particular set of facts which needed its own attention, involving Mr. Couturian in a tunnel.
Yes. Thank you very much, Mr. Kim. That's most helpful. Yes, Mr. Drowell.
Yes.
Can I start with just a comment which is in a way blindingly obvious, but it's important in my submission to remember, keep always in mind that what the issue that this case is concerned with, it's not about the acceptability of wide injunctions against a category of persons unknown. I'll come back to the distinction in a moment. It's about the ability to include in such an injunction or to make an injunction exclusively against newcomers. That's the issue. And accordingly, when we come to, for example, considering the scope of potential injunctions under 187B, the rules of court that are contemplated by the statutory provision are concerned with unidentified people who are, to use a phrase I have time to time, which the court doesn't like, not in existence at the time of the hearing, of the grant of the injunction. The 187B people are people who are unidentified, but who undoubtedly exist and can be seen in a photograph or otherwise described in other evidence. So we need to bear that in mind when I come to some of the passages that I wish to come to. Now, what I intend to do in the reply is to try to deal with the questions posed by Lord Reid at the commencement of the hearing this morning. I want to say something about the factual circumstances in which the Wolverhampton injunction came to be made, and there's a detailed passage in Mr. Justice Nicklin's judgment at paragraphs 191 to 223 of the judgment. The passage starts at page 550. I'll go to one aspect of that passage in a moment. But Mr. Justice Nicklin was plainly aware of the basis on which Wolverhampton puts its case and puts it on which Mr. Anderson has put it again today, and did not accept that it justified the grant of an injunction for reasons which we have already explored to an extent. So if I can go back to Lord Reid's questions. Question one, if the GAML machinery does not work, is there nonetheless a principal basis on which these injunctions can be made? And I take that in three stages. First of all, we do firmly submit that the GAML principle does not work at a stage when an order is being made on the basis that the judge has decided the merits of the application being made to him. That's another way of saying final, but it may work at an interim stage or when the injunction is being sought on a precautionary or emergency basis, but it doesn't work at the stage when the judge has decided that it is appropriate to grant an injunction, albeit with liberty to apply. At that stage, he, by making the order, is exposing the persons unknown to the risk or the risks inherent in making themselves a defendant to the action by entering onto the land and therefore being in contempt. And for all the reasons that we've already explored, we say GAML doesn't work, and we say that nothing in Lord Sumption's judgment in Cameron is to the contrary. So the second issue is whether or not there is an alternative principle basis on which these injunctions can be made. Now, my formulation is that absent new law, that's an important proviso, and I'll come to that in a moment, but absent new law, there is no basis for a final injunction, final in the sense in which I've just been describing it, which binds and which affects the behaviour of newcomers. The problem is general, but it's particularly marked in the case of the Wolverhampton injunction, which creates an entirely novel species of proceeding in which there may never be, and in which there never has been, a defendant at all, despite the existence of an enduring injunction. So, just looking at the state of the authorities, we say there is no basis there's no principal basis for the Wolverhampton injunction absent new law. And thirdly, there is no principal basis on which the law can be modified in this way to create a justification for the Wolverhampton injunction in a traveller context. And indeed, there are aspects of that context which particularly militate against the creation of a new approach to injunctions which are neither final nor interim. So going back over that, GAML doesn't work. I don't think I need to say any more about that. I don't say any more about that. You have on the basic shape of our submissions on that. GAML step 2, what is the position without new law? Now, in our submission, that is authoritatively decided, though I might have been slightly slow to realise quite how authoritatively decided it was, by the judgment of Lord Scott in Fury against LaRue, if that's the right way of pronouncing it, and Spycatcher. If we stop at Fury and LaRue, one can see that the Wolverhampton injunction is crafted so as to bind persons unknown, despite the problems created by the question mark about service and as to whether the injunction would ever come to their notice. So crafted because of the ability for liberty to apply an annual review. And the question is whether that overcomes the fundamental issue of principle which the authorities to date clearly establish exists. And can I ask them, against that background, to go to paragraph 197 of Mr. Justice Nicklin's judgment. And your lordships will find that at page 552, I hope. Yes. And we're in the passage I've already mentioned, which starts at page 550 under the heading "The Injunction Granted to Wolverhampton City Council." And at 552, Mr. Justice Nicklin says, it's not necessary to consider whether this order for alternative service could reasonably be expected to bring the proceedings to the attention of those whom it was sought to make defendants to the claim. That's because he discerns other defects in the injunction. And your lordship saw this morning, because Mr. Anderson took you there, to the fairly elaborate, I accept, arrangements for alternative service set out in the order. But the judge went on to say, however, it's clear from the documents filed by Wolverhampton in support of their claim and injunction that there is a fundamental underlying tension or contradiction between the historic acts of persons unknown who were identifiable even if they could not be named, relied upon to support the claim, and the terms of the injunction, which were directed prospectively at anyone who in the future might set up an encampment in Wolverhampton, i.e. newcomers. The term persons unknown therefore covered two very distinct groups, historic wrongdoers and newcomers. Outside the area of persons unknown injunctions, the inadequacy of proof of historic wrongdoing by A as a justification for a quia timinet injunction against B will be immediately apparent. Further, whatever might be said about the likelihood of the alternative service methods utilised by the Council bringing the proceedings to the attention of the historic wrongdoers in respect of acts alleged to have taken place up to 3 years previously, there could be no reasonable expectation that they will bring the proceedings to the attention of all the newcomers for the reasons explained in paragraph 45 above. I won't take the court now to paragraph 45, but there is some detailed consideration by the judge as to whether the forms of alternative service available or set out in the Wolverhampton injunction would actually work in bringing the injunction to the attention of his second category. So what we have is an injunction that is targeted, that is justified on the basis of extremely unpleasant activity by Mr. Justice Nickling's first group, almost all of which involved the commission of criminal offences for which they could no doubt have been prosecuted or arrested or sought if the police had endeavoured to catch them, and then an injunction that is couched in terms wide enough to catch everybody. I mean, it's no doubt intended to catch all members of the travelling community, but as a matter of language, it catches the world. And we say, as we can see from Mr. Justice Nickling's consideration of it in 197, that is an unacceptable step. So in respect of Mr. Justice Nickling's second category, the persons unknown who have done, at the moment the injunction has made nothing to indicate an intention to move on to land in Wolverhampton, or committed any criminal act, or done anything at all, are caught by the injunction because of its wording. Now, at that stage, the question arises, is it legitimate for this court to sanction that situation by the invention, I don't mean that pejoratively, but by the creation of new law, as it were, which justifies an injunction on the model satisfied in Wolverhampton? I submit the firm answer to that is no. We know the orthodox position from Spycatcher Lord Scott's judgment. We ask whether the position that would result from something couched in the terms of the Wolverhampton injunction is satisfactory. The answer to that is also no. If one considers just the mechanics of what happens to the example that Mr. Justice Nickling considered, I took your lordships to it yesterday, of the single or small group of gypsies in the north of England, I can't remember the location of the place he talked about, it doesn't matter, who wish to pursue their itinerant lifestyle. They come to Wolverhampton, they will find that they cannot get on to the site without being at risk of being in contempt and having the attendant proceedings. They have not been heard, they have not been served, and they have had no chance to justify the impact on their lifestyle, which the injunction plainly has. So we say that for that fairly basic reason, the court should not contemplate what would be a novel extension of the principle of the approaches that the court has taken so far as to the need for the individuals to be within the personal jurisdiction of the court at the moment the injunction bites upon them.
If I may say so, you make a powerful point that to point to the unlawful behaviour, criminal behaviour of a particular group of travellers and say that that's a justification to prevent all travellers from coming is stigmatising an entire category of people in a way that would be unacceptable in almost any other context. You wouldn't do it, for example, with football fans by saying this team's supporters behave badly, therefore we won't have any football fans in Wolverhampton. But so maybe that element should be discounted, but there remains a simple tort of trespass.
Yes, but once you've reduced it back to that point, my submission is that it's all perfectly capable of being dealt with within the orthodox approach and the authorities as they stood to date. Yeah. We know that the fact that you're trespassing is not a knockout blow in the context of the cases, the human rights cases considered in Bromley, and indeed the government guidance contemplates tolerance. Don't move people on immediately, wait and see what's happening, look hard at antisocial behaviour and criminal activity, all of which are in the first group. Once you're not in the first group, then in my submission, the orthodox approach of the case law can be left to do its job, which is to ensure that the only people who are caught by the injunction are those who have been given a chance to be heard and whose activity has given rise to the problem. I hesitate to take this stance, but I do say that the court should hesitate long and hard before intervening in what is a very complex policy area. We put in the bundle of guidance and so on. I'll come back to that in a moment. But there are a number of A, legislative interventions over the years, and B, interventions by policy. None of us in the course of this hearing are capable of expounding in detail and at length what the implications of all of those are. It would push a 2-day hearing into an inquiry, basically. That's simply not within the scope of it. So, and that is the thrust of the passages in Mr. Justice Nicklin's judgment and in the Court of Appeal in Canada Goose, around about 92 or whatever, wherever it is, to the same effect, that this is that it's inherently difficult to use adversarial civil litigation to produce an answer which meets all the problems, and the court should hesitate long and hard in doing it. It's a kind of plea for self-restraint. But the fundamental problem is, fundamental submission is that if you look at the division in 197 of Nicklin, the paragraph I just read, the problem, which is insuperable, I'm not going to comment about whether it arises to the same extent in protester cases like HS2. The problem with traveller cases is that the whole justification of government policy is to some extent a hands-off approach, a tolerance of trespass, not moving in too fast and too hard at the beginning, because of the characteristics of the lifestyle of the gypsies and the travellers. And you have to couch the remedy in a way which respects that. Once you've got that far, as I say, well, there's no reason for not letting the authorities do their job. Now, it's partly for that reason, which I've already foreshadowed, that I say the particular characteristics of traveller injunctions militate against this being an appropriate case in which to fashion a larger, a different basis for a different and principal basis for injunctions.
The issue one has put to us is broader, isn't it? Because newcomers is defined to include persons who weren't parties to the claim when the injunction was made.
Is that the way in which it's put?
None of them would be persons who were parties to the claim.
Well, that may be partly my fault, but
I'm not is in relation to the newcomers in the sense that they haven't even made up their minds whether or not to travel to that particular area when the injunction is made.
Well, I'm sorry, can I just make sure that... No, parties to the claim when the injunction was made. When the injunction was made, not when the parties... Yes, that formulation is deliberate. There may be some people who do intend to travel to the site but who weren't parties to the claim, but we don't know anything about them. The formulation in the Wolverhampton injunction, and indeed all the injunctions against this category of persons unknown, is and couldn't be targeted at someone who has already formed the intention of moving onto the land. That requires an investigation into intent, which is not realistic. So I stand by the formulation, that formulation. They needn't necessarily be parties at the moment that the claim is issued, or at the time of the interim injunction, because this is not an attack on gamble as it applies to interim injunctions, or to there being some other machinery at which people who come onto the land during the currency of an emergency injunction can be heard at the final hearing. But if you're trying to sweep into what I call the final injunction, then you immediately hit the problems that I've been trying to describe. And those are particular problems, or they make it particularly inappropriate for traveller cases to be the case for the formulation of a new and wider approach. And I won't ask your lordships to go back to Bromley. Bromley keeps on not quite getting the consideration from me that it deserves, because it is a very important decision. And again, it's important to remember that it applies to both of Mr. Justice Nickling's cases. It applies both to people who are identifiable, even if not identified, at the time of the making of the injunction. It applies to them, and therefore does justify a wide injunction, even if that, for the reasons I'm developing, can't include newcomers. So we say it may follow from what I've already said, that other particular features of the traveller context in relation to newcomers include the way the proportionality exercise must work in relation to them. It's a highly individual exercise. I ask the court to bear in mind Lord Justice Brown's judgment in South Bucks. It's set out in Bromley, the long passage. Proportionality in this context requires consideration of the individual circumstances of the gypsy or traveller, his state of health, motives for travelling, the availability of alternative accommodation, and so on. And you can't, that obviously won't happen at the stage of the sort of proportionality exercise that we've seen leading up to Wolverhampton. They just don't know anything about their identity. And the second aspect, which makes the traveller context a particularly inappropriate way to do it, is the importance of cumulative impact. Can I just say a word about that? One of the issues that the court did bear in mind in Bromley, and which we would ask the court to say was an essential, well, if it's going to deal with this at all, to say is an essential aspect of an injunction covering any group of travellers or gypsies, is the number of sites that are covered by it and the availability of alternatives. And the Wolverhampton site the Wolverhampton injunction covered 60 sites. My learned friend Mr. Anderson submits that doesn't create a particular problem, because there are alternative sites available within Wolverhampton. But there's a catch-22 element to that. The sites have been selected on the basis that they are the most vulnerable sites, i.e. the sites which are most likely to meet a need of the gypsy or traveller community. So it's only a partial answer to say that you can go elsewhere. You're still confronting, you have a series of these wide injunctions covering 60 sites in Wolverhampton and however many sites elsewhere, with a cumulative impact which impacts very severely on the way of life, as described in Bromley. So one needs to be careful about the justification, about a line of reasoning that says it's good enough to say that you haven't covered everywhere in Wolverhampton. You may still have had a very big impact on the overall cumulative effect. And obviously, as Lord Justice Coulson says in Bromley, it also depends on what's happening in the next door borough and the next door borough, and so on. So can I just spend 2 minutes on the...
There'd be nothing to excuse, assuming you're right about cumulative impact,
yes,
it's a relevant consideration. A local authority that comes along on an essentially ex parte basis under a duty to make full disclosure would probably be required to find out what restrictions there already were in neighbouring areas and tell the court when seeking its injunction.
Yes, I mean, principal comment on that is that it's asking the court, in a kind of the context of a 1 or 2 day hearing, to carry out a kind of policy investigation of what is happening to site supply in the Midlands, for example. Now, the moment you've got that as a critical ingredient in deciding whether or not the injunction is justified, something has changed about the nature of the exercise that's being carried out. It's not a normal adversarial exercise. It's obviously different if you have identified individuals who have committed criminal acts and whose behaviour is unacceptable. Mr. Justice Nicklin's first case. But we're not talking about that, at least I'm not talking about that. We're talking about the second category of people innocently, if I can put it like that, or exercising a lifestyle which may involve trespass. We know that's not necessarily the end of the world on the basis of the government guidance, and not being caught by a machinery in which they have not been heard at all. So it's very tempting to think that one can design a machinery which copes with all of this, and which the judge in a hearing that's non-adversarial in the sense no parties turned up other than the council, to carry out this exercise. And no doubt the judges will try hard, as they did in the Wolverhampton case, and as they did in Bromley, where the injunction was entirely correctly refused. But it's a big exercise, and I would ask the court to hesitate before approving the possibility of injunctions, even with all the safeguards that we've been discussing built into it. Yeah, Mr. Willis is correctly pointing out that if your lordships look, I'm not going to ask your lordships to do it now, but at paragraph 11 of Bromley, Lord Justice Coulson does consider the impact of the injunctions that have been granted in the flurry of injunctions that were granted in the period leading up to Bromley. Now, it's not, I respectfully submit, it's not a sufficient answer to that, to say, well, we're going to have safeguards like liberty to apply and time-limited injunctions and so on. And I think I am entitled to step back and say, well, you only catch persons unknown if you comply with the principles in the leading cases like set out in the judgment of Lord Scott, unless there's a very clear and principled basis for departing from it. Now, I think it also follows from that, when Mr. Anderson invited you not to depart from a jurisdiction that had been developing for decades. I just don't accept that that is the position. The examples of Bloomsbury is an easily understandable case dealing with the need to preserve the asset, namely the book, before its unauthorized publication. In my submission, it will make no difference whether the injunction was final or interim. If you, a stranger to the injunction, nonetheless ensure that the purpose of the injunction is defeated by handing the book into someone else's hands, then you are caught by the second limb of the spycatcher approach. You're not caught by the fact you're a party to the injunction, but you are caught by the fact that you're knowingly frustrating the purpose of the order is being granted against somebody else. And I think I've dealt with 187B. It's, I don't know if it was Bolton's example. With my submission, we've covered that already. It's dealing with something different. And I think the final point, I'm not making submissions about the appropriateness or otherwise of the HS2 order, although it may have difficulties based on my submission. But the order itself is not a good precedent for transposition into a gypsy context. If you look at page 1903, the bundle, we're in a schedule to the order. What is envisaged is an elaborate machinery under which individuals, potentially protesters, can make an application for permission to apply to vary the order. So, whether or not that's appropriate in a protester case, plainly, machinery of that sort of elaborate nature will plainly not be appropriate in the cases to which I'm concerned. Because for the reasons given by Mr. Justice Nicholson, it's extremely difficult to see the traveller, who is a stranger to the land at the moment, actually applying in advance before he sets off on his journey to discharge the order. It's just not a realistic way of looking at it. So for all those reasons, we say go back to the classic case law and you get the answer. These are my submissions. I hope I haven't trespassed too much on the time.
Thank you very much. Thank you very much, Mr. Drabble. Well, we're grateful to all counsel and those others who've no doubt been involved for very helpful submissions. This is one of a number of important and rather difficult cases that we currently have on our books. We will do this one as quickly as we can, but that's not to say it's going to be quick. Court will adjourn.